In this video, we will conclude our look at the buyer's remedies available whenever the seller breaches by failing to tender the goods that she was obligated to. And we will conclude by considering what additional indirect damages may be available to the buyer. Let's start first by distinguishing indirect damages from direct damages. The cover damages and market damages that we looked at previously are two measures of the buyer's direct damages. Direct damages compensate the non-breaching party for the lost value of the breached contract, the value that would have directly resulted for the buyer from the seller having delivered the goods as she had promised to do. The non-breaching party, however, may also have indirect losses. For example, a buyer may incur expenses and delays in finding substitute goods once the seller breaches, and in the meantime, while the buyer is looking to procure substitute goods, the buyer may lose business and additional profits because it did not have the necessary goods in time to meet its own customers' needs. To truly protect the expectation interests of the non-breaching party, it is important to compensate the non-breaching party not just for its direct losses, but also for these types of indirect losses that may also arise from a breach. The common law of contracts, and the UCC generally, distinguishes between two types of indirect damages: incidental damages and consequential damages. This common law distinction is codified in Section 715 of Article 2. Specifically, incidental damages are codified under subsection 1 of 715, and consequential damages are codified in subsection 2 of 715. So let's start with incidental damages first. Very generally speaking, incidental damages compensate the non-breaching party for the losses she incurs in coping with the breach. In a situation where the seller has breached by failing to tender the goods, what kinds of additional losses might the buyer incur? Most obviously, it would be the cost that the buyer incurs in finding and arranging for a cover transaction. Note here, we are not talking about the cost of the substitute goods themselves in a cover transaction. After all, the cost of the cover transaction itself may be recovered as direct damages by the buyer under Section 712 of Article 2. Instead, we're talking about incidental expenses that the buyer might incur associated with a cover. Things like any brokers or middleman fees that the buyer has to pay to find substitute goods, the cost the buyer might have to pay for shipping substitute goods from a distant or far-flung seller, or the cost the buyer might incur in paying for expedited shipping to get the substitute goods in time. All of these expenses may be incurred by the buyer to deal with or cope with the seller's breach. Subsection 1 of 712 defines the kinds of incidental damages that are recoverable by the buyer. Subsection 2, in turn, defines the kinds of consequential damages that are recoverable. Again, very generally speaking, consequential damages compensate the buyer for losses that are more removed or indirect as compared to its incidental losses. As the name implies, consequential losses arise as a consequence of the seller's breach and are not directly related to the value of the breached contract itself. One very common example of a consequential loss that a buyer might claim as damages is for its lost profits. The buyer's claim is essentially that the buyer would have made sales to its own customers, or that the buyer would have secured other business opportunities if it had the seller's goods in time as promised. But the buyer was unable to make those sales or capitalize on those other opportunities and therefore lost out on some amount of profits in its own business, all as a consequence of the seller's breach. Stated more simply, the buyer's own business suffered lost profits as a result of the seller's breach. Indirect damages of both types, both incidental and consequential losses, are always available for the buyer to recover. But the recovery of such damages is subject to three common law limitations, which are briefly described in your reading and that you likely covered in your study of the common law of contracts. These common law limitations are codified to varying degrees by Article 2, specifically in 715 subsection 2's description of consequential damages. And it is in this context of consequential damages that these common law limitations on recovery have their most pronounced effect. But to the extent the common law supplements the UCC, these common law limitations apply to also restrict the buyer's ability to recover incidental or even direct damages. Although unlike consequential damages, for direct and incidental damages, these common law limitations are much less likely to be relevant. So what are these restrictions on the ability of the buyer to recover damages? The first is the requirement of foreseeability. This requirement is sometimes referred to as the Hadley rule, or the principle of Hadley versus Baxendale, because it is so closely identified with the case Hadley versus Baxendale, an old English common law decision that you may have covered in your study of the common law of contracts. It's the broken crankshaft case. The principle arising from that case is simply that the only losses that the non-breaching party, that is the buyer in this scenario, may recover as damages are those losses that were foreseeable at the time of contracting. So the buyer's losses must arise from circumstances that the seller had reason to know about at the time of contracting, losses that the seller could have foreseen. In practice, this means that if the buyer had a special or particular need for the seller's goods, which made the seller's failure to provide the goods especially damaging for the buyer beyond the losses that would be suffered by any other buyer, then the seller has no liability for such additional damages to the extent the seller did not have reason to know about the buyer's special circumstances. Most commonly, this principle arises to limit the buyer's ability to claim consequential damages for its lost profits in the buyer's other business dealings, due to the seller's failure to provide the goods it promised. The Hadley principle is codified under subsection 2 of 715, which says that consequential damages include any loss suffered by the buyer resulting from general or particular requirements and needs of which the seller at the time of contracting had reason to know about. So if the seller did not and could not at the time of contracting have reasonably known that as a consequence of the seller's breach, the buyer would suffer higher than ordinary losses because of the buyer's peculiar circumstances, then the buyer cannot recover damages for the full extent of its losses. Specifically, the buyer cannot recover beyond the losses another ordinary buyer would have suffered under normal circumstances. The second limit on the buyer's ability to recover damages from the seller is the requirement of avoidability. This principle provides that the only losses that the non-breaching party, the buyer in this scenario, may recover as damages are those losses that were not reasonably avoidable. Sometimes this principle is referred to as the non-breaching party's duty to mitigate her damages, but that description is misleading. The non-breaching party technically has no legal duty to mitigate its losses arising from the breach, but the non-breaching party cannot recover damages for losses that could have been reasonably mitigated or avoided altogether. Stated differently, avoidable losses are not recoverable as damages by the non-breaching party. Like the foreseeability requirement, the avoidability requirement is codified under subsection 2 of 715, which says that consequential damages include any losses suffered by the buyer which could not have been reasonably prevented by cover or otherwise. So if the buyer suffers consequential losses that it could have reasonably avoided, those losses are not recoverable against the breaching seller. A third and final limit on the recoverability of damages by the buyer is the requirement of reasonable certainty. This common law principle is not codified at all in the UCC, but it still applies to the extent the common law of contracts supplements the UCC, a fact that is recognized by comment 4 to 715, which specifically mentions the requirement of reasonable certainty. The basic principle here is that the non-breaching party, the buyer in this scenario, may only recover for losses that it can prove with reasonable certainty. Stated differently, the non-breaching party, the buyer, cannot recover damages for losses that are speculative. If either the existence of its losses, that is, the fact that the buyer actually suffered losses as a result of the seller's breach, or the amount of those losses are abstract or hypothetical and not reasonably certain. Thus, the buyer bears the burden to prove with reasonable certainty two distinct elements to recover damages. One element is of causation. The buyer must prove with reasonable certainty that the seller's breach in fact caused the buyer to suffer losses. The other element is of measurability. The buyer must prove with reasonable certainty the extent or amount of the losses that the buyer suffered as a result of the seller's breach. Note what is not required of the buyer. The non-breaching party need not prove her losses with absolute certainty. The buyer must simply provide some objective evidence to show that it has suffered a loss and the approximate amount of that loss. But the requirement of reasonable certainty can become particularly problematic when the buyer is itself a new business, a business without an operating history or track record of profits. For a new business, any lost profits are necessarily speculative, and therefore, in the typical case, it will be difficult, if not impossible, for the buyer to prove with reasonable certainty that the seller's breach caused the buyer to lose future profits. One final note. Even though the limitations of foreseeability, avoidability, and reasonable certainty are only mentioned in the UCC in reference to consequential damages, where these limitations tend to matter most, under the common law of contracts, these limitations apply to restrict the non-breaching party's ability to recover damages of any kind for any loss, including damages for direct or incidental losses. So to the extent the common law supplements the UCC, These principles may potentially apply to limit the recovery of all types of damages that the buyer may suffer as a result of the seller's breach. But as we said, where these limitations tend to have their most pronounced effect is on the ability of the non-breaching buyer to recover consequential damages for lost profits resulting from the seller's breach. So that concludes our look at the buyer's remedies in the event the seller breaches a contract for the sale of goods by failing to tender the goods altogether. Recall that in this week's module, we looked at limited circumstances under which the buyer may seek specific performance or other related non-monetary remedies that would result in the buyer actually receiving the goods from the breaching seller. And then we focused on the default preferred remedy of money damages and the direct cover or market-based damages available to the non-breaching buyer, along with the indirect, incidental, and consequential damages that the buyer may also recover. In the next week's module, we will consider buyer's damages in a different scenario, where the seller tenders the goods that the parties contracted for, but that tender fails to conform to the requirements of the parties' contract.